Hello everyone, and welcome back to another episode of the Darrell Brooks saga. On today's episode, last episode, I think my brain just got into mush. It was, I felt it reduce in size like 2 times, like the Grinch, but it just for my brain. So we're gonna try to give it back to his original shape by listening to Judge Darrow and Attorney Upper, so they can give me some sense into this conversation. Thank you for watching. Again, I'll make these videos every day. If you're interested in more or you want to go back and see more, just please subscribe. I'll really appreciate it. And thank you. Let's get right into the video.
Mr. Brooks
Knowingly?
knowingly,
To being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please
The first thing that he wants to do when someone else is speaking is cut them right off. Like, he can talk for hours on end, but as soon as someone else is talking, no, that's not me. It's not my attention.
continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court,
Arrogant.
whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator, if he accused this court of treason.
He did.
But I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn.
Yes.
At every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement.
Yes.
The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender.
And I love this. I love that she's calling him out about it. It's like, you didn't prepare. You're just using whatever they left you with, and that's what you got. That's all you gotta do. That's why you then get to all these nonsense questions.
He is not going into this blind or
No.
with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement.
Yes. Thank you.
There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial.
Never.
He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial. And on the other hand, we're rushing him to this case, and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say,
Yes, he
I
does.
only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him.
Tell him.
He
Tell him.
has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. And again, you warned him, Judge. You
Yes.
fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that
I wanna
from
know
where
who
I'm
gave him
sitting.
that- gave him that.
I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
You see, I wanna jump in here and see how easy it is for her to just completely destroy any arguments that he made during that time. It's like it's just facts. She just has to state the facts to the court, and that's it. He has no answer to that. But let's see how he answers to this.
Objection to that.
Objection, of course.
Your Honor, that's a load of crap.
A lot of.
Mr. Brooks, that's my
I'm not gonna
opportunity
say
now.
it, but
I
you're not
gave you
supposed to
about
say that on court.
50 minutes.
I just want to object to the disrespectful comments that was just made.
Wow.
I'm not trying to hold you up from what you're gonna say,
But I am.
but that's a load of crap.
It's not.
Mr. Brooks.
For her to sit there,
Mr. Brooks.
for her to sit
your
there,
objection is noted.
for
Shut
her
up.
to sit there, Your
No,
Honor.
it's my turn. Let me go through this. I graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure.
Yes.
I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point. Please listen.
Yes. Shut up and
Please do
listen.
not interrupt. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact.
Just nonsense.
There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining or sustaining, I
She
should
said
say,
substaining.
or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further.
Nope. No
The
one
fact
cares.
that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha.
Yes.
The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases.
Boom.
That
There you
is
go.
clear.
Easy. Transparent. Clear.
The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. The fact that you complain about what I do, it's noted. The record is going to be very clear. All right? I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record.
Thank you.
I sometimes do that to hopefully make it clear to you or to note it. I don't always do that, but I'm not required to do that. Those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir. And this court need not address them further.
Nice.
Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time. So I'll instruct Madam Clerk to bring the jury out.
Thank you. All right. So now, two people, two really experienced and knowledgeable of the law people, has said that everything he said is baseless, is frivolous, is nonsense. Right? Now let's see how Mr. Lawyer Darrell Brooks, what he has to say about it.
Didn't bring up the Higgins-Levine 415 U.S. 533 decision. That was not addressed, and the issues are still not addressed. There's still been no proof to anything that you said, anything that the prosecution has said. There still hasn't been.
Is noted, and we will continue. Bring the jury out, please.
There still hasn't been
Mr. Brooks,
any proof.
I've addressed them
There
to the
still
extent
hasn't
that
been
I
any
will.
proof. There still hasn't been any proof.
Any proof?
I never once.
He's
The
still trying
comment
to
about
talk.
me not flinching was when you said that there's 66 years of experience at that table. That's the comment I said that doesn't make me flinch. That was mischaracterized. That should be for the record. There's still
Noted.
been no.
Noted.
There's still been no proof.
Mr.
about-
Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction,
Because
whether
it's not.
there's anything
It's not.
along those lines. It is frankly not required under the law. You may disagree with that. You can take that up on appeal, whether that's an interlocutory appeal or whether that's a direct appeal if there is a conviction. But I'm not going to address it any further.
There you go.
Because there's no verified proof.
There does not need to be, sir. All right, I
does
believe the
need to
jury
be.
is coming out. Is
It
that true?
does.
In order for a case to.
All right. The
To
record
go
should
on, there should
reflect
be
that the
proof.
jury is coming out, and we are about to continue with the state's next
Not once
witness.
was the plaintiff addressed. That wasn't addressed.
Because it doesn't need to.
Where's the plaintiff? Where's the injured party?
Now he's talking for the jury.
That's because
The jury will disregard the statements presently being made by the defendant.
Because y'all don't want the jury to know the truth.
The jury will disregard those statements
I understand.
made by
He
the
understands.
defendant.
I see.
It is not his opportunity to
what
testify.
he's
They are
doing.
comments, and as such are to be disregarded.
I see what's going on. Ain't gonna work.
All right. Thank you, everyone. You may
Hear that? He said, I see what you guys are doing. It ain't gonna work. Some of you who already seen the trial know if that worked or not. Let's move on.
be seated.
It's not gonna work.
It's not gonna work.
Attorney Opper, you may call your next witness.
Ma'am, on the day of November 21, 2021, did you attend the Waukesha Christmas Parade?
We did.
And was one of the people that was with you your daughter?
Yes.
And what was her age at the time?
Her age at the time was 10.
10.
Okay.
First of all,
During the parade, were you present when the dancing grannies were struck by the red SUV?
Yes.
And did that get captured by your daughter on her iPhone?
Yes.
nice, an iPhone.
Display Exhibit 139.
I have an Android.
To the witness only, please.
Go ahead.
We're going to just play it for just a few seconds first to make sure you can look at it and identify this, that we're talking about the same video you provided in this case, okay? So
Yes.
we'll play about three or 4 seconds worth here. All right, does that look familiar to you?
Yes.
Okay. Is this the recording that your daughter captured that afternoon?
Yes.
And same recording that you turned over to the Waukesha police?
Yes.
All right. Move to admit number 139,
Oh,
permission to publish.
I guess now he has his answer, because remember in the past he was asking who took these videos. We don't even know where they're from. How are they relevant? Well, now you are seeing who they took them.
Objection.
And he's objecting to it.
Exhibit 139
Because,
is
of course,
received.
he is.
Permission to publish is granted. The objection is overruled.
Ah, please don't. Ah, it's like gunshots. And I'm sure he's gonna be just like,
Sevens, is that what you remember seeing that afternoon?
Yes.
Did you hear those loud thuds?
Yes.
we all did.
Thank you. I don't have any other questions. Mr. Brooks may have some questions for you.
Any cross?
Yeah, and I object to being called that name again, and I don't consent to it again for the record.
Okay.
Noted.
Move on. Ask a question.
During the parade, were any of you or your family injured?
No.
Do you recall seeing a vehicle approaching?
Yes.
And about how far was it from you when you saw it approaching?
To the electrical box?
Roughly, like, I don't really know of an estimate of the amount distance. It was roughly when it started hitting the dancing grannies.
Did you see the vehicle strike anyone before that point?
No, the crowd was rather large at the parade.
Do you remember the large crowd? Do you recall it being pretty loud at that point?
Every parade I've been to has been loud in general, so
So it'd be fair to say that one was pretty loud.
yeah,
Sure.
I suppose.
Did you hear at any time
At
a
any
report
time.
of shots fired?
No.
Did you hear any shots?
It was loud and chaotic. I can't say for sure if I heard shots or not.
So would it also be fair to say that if a horn may have been blowing, you wouldn't have heard that either?
I would have heard a horn. We weren't that far from where the vehicle came through
Yeah.
on the road.
So it'd be fair to say that you think you would have heard a horn, but not shots.
Yeah, because those were after.
I didn't hear any shots when the car went past.
No, I'm not asking when it went past. I'm saying the question was at any time. So I should have been more clear. I apologize.
Yes, you should.
At any time.
No, that's not being more. Oh my
Anytime.
God. Why is he? He just said himself, I should be more clear. And then he comes back with at any time. What?
During that moment.
I don't believe I heard gunshots. I've never heard a gunshot before, so I can't really say yes or no.
So it'd be fair to say you wouldn't really know what a gunshot would sound like.
No.
Correct.
In the movies, maybe, but that's different.
Seeing as how you've never heard a gunshot before, would it be fair to say that it might be really loud?
What?
I wouldn't know. I've never heard a
What
gunshot.
kind of question is this? Like, I know you haven't heard anything like this at all before, but can you say that it's loud? How would she know? She doesn't know.
So I wouldn't be able to guess.
Do you recall if it was any music playing?
It was a parade, so
Well,
there was music at some point. Marching
coming from any of the vehicles in the parade?
I don't recall at the moment.
When were you notified that it was? When were you notified that it was a possibility that you may be called to testify in this matter?
I received correspondence in the mail. I don't remember the exact date of when I received it. August, I think.
So, not that long ago then would be accurate.
Yeah.
Or pretty recently, rather.
Yes.
What does that matter?
Do you recall if that was in subpoena form?
Yes.
Did it state by whom the subpoena was sent?
The district attorney's office.
Did it have a name?
Susan?
Did you seek to testify in this matter?
No.
She was subpoenaed.
Did the district attorneys ever tell you in any way that they were the plaintiff in this matter?
What? Here we go with the plaintiff stuff.
Those words were never spoken to me.
Are you aware of any plaintiff in this matter? Grounds.
Irrelevant.
There we
Grounds.
go. Here we go.
Sustained. You have to answer that.
Grounds for the sustain, Your Honor.
It's not relevant. Doesn't matter.
Next question, sir.
You've been told this way
Did
too
you
many
or
times.
your husband or anyone in your family that was present at the parade file any claims on the matter?
With who?
He's confused.
Understand the question.
Not really.
We all are.
Please rephrase.
At any time, did you
At
file
any
a
time.
claim with any, I guess, the agency or anything like that?
The agency?
In regards to the incident?
No.
What is the agency?
Did any information that you obtained in regards to this incident have a complaint with it? Grounds.
Sustained as to the form of the question.
Have you ever seen any complaint related to this incident? Grounds.
Sustained as to the form of the question.
Do you know of any complaint with this incident?
You just asked that.
Not sure I completely understand.
I don't know how
the
he does that with his
question on
forehead. I
that.
cannot do it. I can get one line maybe.
What kind of complaint? I mean,
Please rephrase.
Have you ever seen any issued charges in relation to this incident?
I'm sorry.
Grounds.
Issue
I
charges?
did not understand what Mr. Brooks just asked, Your
Not
Honor.
even Susan
He
knows
said
what
the
he's talking
issued
about.
charges.
I object to that on relevance grounds, Your Honor.
Grounds.
Overruled. She may answer.
I haven't really been keeping up with the news media on the trial. So, no, I haven't seen a list of the charges.
I was referring to if you had received anything from the district attorney's office about the charges issued.
No.
Then why you didn't ask that? Ask that if you want to know that.
Are you aware of anyone bringing any claims or suits?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained. You don't have to answer that.
Grounds. Grounds.
Grounds for the sustain, Your Honor.
Grounds for the
Next question,
sustain.
please.
How many grounds do you need? Grounds for the sustain?
Can you recall if you saw any tents to the vehicle you saw? And by tents, I mean like tinted windows.
Again, this is also something that bothers me. He always asks, did you see any tints? And then he has to clarify any tinted windows. Why don't you ask that from the beginning?
Of that nature.
I don't recall if the windows were tinted or not.
There you go.
Do you recall where the vehicle traveled after it passed you?
No, my priority at that point was to get everybody inside and make sure they were safe.
So you didn't observe anyone struck after what you saw initially?
Correct.
That,
And you stated that you
That
haven't
makes you
really been
innocent?
keeping up with the incident, right?
right?
Correct.
So that mean that it was your choice to do so, or you just kind of just disregarded it?
What?
Grounds.
Yeah, what does that
Sustained.
matter? Why does that matter? It doesn't. He just
Grounds for
didn't
the
do it.
sustain, Your Honor.
Next question, please.
Just for clarity, you are not aware of
Again.
any plaintiff in this matter, correct?
Asked and answered.
That.
Grounds.
The
Is that an objection?
The objection is sustained. You don't need to answer that.
I think you said that you were contacted back in August, correct?
I
She got a
received
letter.
mail with the subpoena, yes.
Do you recall before August being contacted in connection with this incident?
Objection.
Grounds.
Repetitive. Irrelevant.
Grounds.
Sustained.
Grounds for the sustain, Your
Why
Honor.
does that matter?
Next question, please.
No grounds.
There's grounds. You don't need
Next
to know
question,
them.
please.
Would you consider yourself an injured party in this incident?
Objection.
Grounds.
Repetitive.
Yeah,
Irrelevant.
You already asked
Grounds.
that.
Sustained.
Wait, how many
Reason
times
for
did
the
you say grounds
sustain, Your
there?
Honor.
Next question, please.
Let me just go back.
Objection.
Grounds.
Repetitive.
Grounds.
Irrelevant.
Grounds.
3 times.
Sustained.
Reason for the sustain, Your Honor.
And then the
Next
reason for the
question,
sustain.
please.
No further questions.
Thank you.
Any redirect.
No, Your Honor.
Thank you, ma'am. You may step down.
Thank you.
All rise for the jury, please. We are in recess.
Nice. I think I can go for another.
Thank you,
witness.
everyone. Please be seated. All right, we'll bring the jury out.
Subject matter jurisdiction, Your Honor.
Every
Still
break.
have yet to be verified.
No, it does
Your
not.
objections noted.
Was my ICF obtained by clerk of courts?
How would she know?
The one requesting the copies of various documents?
The one asking for the complaints.
Yes, my understanding is they're working on it.
Just wanted that clear for the record.
We came up with the speed of the vehicle, or average speed of the vehicle during that segment of 32 miles an hour.
32 miles an hour as an average speed from point
Hey,
A
Zach.
to point B
I
as
like
they're
Zach.
depicted on this diagram.
That's like a gun.
Correct.
Witness.
Can you maybe explain for us the purpose of using an exemplar vehicle in your analysis?
Well, when I worked with the detectives from the City of Waukesha PD, we wanted to find an exemplar vehicle just due to the type of case this was. They were able to easily locate one that was very convenient to use, matching the description, I believe the year, make, and model of the car that was in the actual parade.
You used a 2010 red Ford Escape.
Correct.
Okay. Do you happen to know the curb weight of that vehicle?
Yeah.
And I want to say this. I don't like Ford. If you, I don't know if you guys use Fords, but I used them in the past and they're not that reliable. I'm usually a Honda guy, like a Toyota guy. Don't buy Ford.
You may answer.
This particular 4x2 vehicle was 3,368 pounds curb weight.
Okay. Can you say definitively that at any point between point A and point B, the vehicle was traveling faster than 32 miles an hour?
Objection here.
Could be. It's not hearsay.
Overruled. You may answer.
Speculation at best.
It's an average. Is it possible the vehicle maintained a constant speed of 32? Yes. But it's more plausible that you have higher and lower speeds during that segment.
Cross.
Yes.
Here we go.
This is kind of distraction still being on there.
Yeah, take this evidence out of my
Any
face.
reason why the average speed wasn't depicted in the exhibit?
That's just a calculation that we do that's included in the report. I don't normally do that in the diagram.
Yeah, it's in the report.
So it would be fair to say that you created the diagram?
I did create the diagram, yes.
You said normally you don't put the speed calculation in the diagram. Would it be any reason for that?
It's in the report.
Yeah, it's already
not
there.
necessary to put it in the diagram.
Have you ever done that before?
Could you rephrase the question?
Have you ever not included the speed analysis in any crash reconstructions that you've done before?
It's
Before this
there.
one?
It's on the report.
Are you referring to the diagram or are you referring to the
Referring
report?
to the diagrams.
No,
I'm
I
sorry.
don't. I do not put speed calculation results in diagrams
On any of them.
on any of them.
Did you create any diagram with the speed calculations present on it?
He already
No, I
said
don't.
no. He already said like 3 times no. He's saying that, oh, I didn't see the speed calculation on the diagram. It's easier for me to just look at the picture and know all the information, but that's not how it works. That's not how he works.
The diagram that I created is the one that was up on the screen.
And then from there you put the speed calculations just in the report.
Yes.
Yeah, I normally just put them in the report, yes. I don't have any recollection of putting one in the diagram.
Would it be fair to say that it may be a little bit difficult to
This is incredible. He's like, I can't find it. Why I can't find it on the report? Just put it in bright red letters on the top of the page.
locate
he's
what you
looking for it.
analyze for speed if it's not in the diagram?
No.
No. You just read the report. You just prepare. What?
So if you wanted to know the calculation of the speed, you would have to read the report.
Yes.
Correct.
What
Would
is
it be
this
fair to
question?
say that it might be easier to find if it was included in the diagram?
No, it's
My
in the
report is, my diagram is included with my report, and that's all one unit, so it is in the report.
Yeah. What?
You made reference to something called Newton's law. Can you explain a little bit further what that is?
What? What? What is Newton's law? Are you for... He's serious though. Look at his eyes. He's serious about this question. Is what is Newton's law? Are you kidding me? This is... I don't know when this was told, but this is like fourth, 5th grade. Tell me in the comments, when did you guys learn Newton's law, please?
Newton's laws of motion are what we use as a big step in our reconstruction field. A lot of formulas are derived from Newton's laws, including the formula that we use to calculate the vehicle's average speed. Sir Isaac Newton obviously invented the laws of motion. We all learned that in high school.
High school.
And that's
Thank you.
part of the process that came to the
I
formula
love-
that I use to calculate the
I love that sneak punch. It's like, we all learned this at high school.
average speed.
I love this guy.
I always thought of Newton as gravity, so that was a bit of new information.
Why are you laughing?
You made reference to part of the crash reconstruction was finding a similar vehicle. Would that be fair to say?
Yes.
And you were able to find a similar vehicle pretty easily, you would say?
That would have been the City of Waukesha Police Department which found the vehicle.
It's a fort. No one
And
really
you made
wants
reference
them.
to it being in the parade as well? Or part of the parade as well?
The exemplar vehicle?
Yes, the vehicle that was similar.
That's not what he said.
The exemplar vehicle was not in the parade.
I may have misinterpreted what you were saying. Do you recall if that part of your investigation and the creating of the graph and all that technology that goes with that, was that part of the same day, or were they done on at different times?
I'm sorry, are you referencing the diagram, the creation of the diagram?
Right.
No, that was
Because
not.
it seems like a lot of technology went into getting the diagram created and, you know, different variations of that. And then also using a similar vehicle to, I guess, simulate would that be fair to say, simulate the incident?
We use the exemplar vehicle for our testing.
What, was that done all the same day, or was it done?
Sorry, could you rephrase the question again? I'm not understanding what you're asking.
Was the creation of the diagram and the simulation of the vehicle done on the same day?
No, it was not. The testing was done on January 30th.
Yeah. You collect
And
data
what
and then you
about
make the
the
report.
simulation from the similar vehicle?
I'm sorry, could you rephrase the question?
Do you recall what date the simulation was performed?
All right, are you asking when I completed my analysis?
Specifically the part of the similar vehicle being used.
That was January 30th. We did the testing out on Main Street in front of Curry Insurance.
So what part of the process was done at a later date?
The diagram, the calculations, the time distance analysis.
You know, the scientific method. You know, you see how this guy really struggles when experts come in? Like, we see the same with the guy with the expert that he tried to discredit because he wasn't. Is there someone else that he doesn't know how to ask intelligent people, any people, like everyone is intelligent, but experts, he really has a hard time asking experts about stuff. He's so outmatched, he doesn't know what to do.
Do you recall the date of the second part of the investigation?
Are you referring to when I completed my reports?
Yes.
No, I don't know what day that was.
Was it sometime after the January 30th?
Of course
date?
it is sometimes
Correct.
after.
Would you say there was a delay in finishing it, or did something cause you to kind of... Let me rephrase that.
Thank you.
Was there anything that may have delayed you finishing the investigation quickly?
Can you rephrase? What do you mean by quickly?
Yeah.
By it seems like there was two parts of it: getting the simulation done and then the actual diagram and things of that. Any reason why that couldn't be done closer together?
Well, first of all, it's not a simulation because a simulation is different than what we did. This was just some testing we did out at the scene. Secondly, you know, as I mentioned earlier, I respond to hundreds of crashes. You know, it depends on what I'm working on at the time. Once our reports are completed, they need to be peer reviewed. All that process takes time. So there's nothing that delayed my report. If you want to use me going to another crash, that possibly could have delayed it, but no delays that would affect the outcome of the report or the accuracy of the report.
No, I wasn't going to that part of it. I was just kind of curious what may have spaced out the dates. That's
You're
what I
not
was
the
really
only
getting at.
crash.
We do a lot of reports every year, and
You're not
obviously
that
we're
special
not just
to-
doing one report a year.
Did you perform an external examination of an individual identified as Leanna Owen?
Yes.
All right. I'm gonna cut it here. Tomorrow we're gonna come back. This is the episode for tomorrow is gonna be a really tough one because now we're gonna get into what happened, like the victims per se, and I'm not looking forward to that. But all right, thank you for watching today. Leave it a like if you made it this far, and I'll see you guys on tomorrow's episode. Bye bye.